Hello everyone. In this video we are going to talk about case briefing part 2, and I'm going to use Boy Scouts of America versus Dale to illustrate how you should be preparing this. I do want to start off by saying that I cannot emphasize how important it is that your case briefing be your own. That means you read the case excerpts that are provided to you and you brief the information. You should not be using outside sources to do this. Particularly if you had used outside sources in this, even though you weren't supposed to, you should have at least cited what you were using because it wasn't your own work. If you fail to do so, then you will flunk the entire case brief for this component. The whole purpose of a case brief is so that you understand the case briefing. So please make sure that you do your own work, meaning you don't use outside resources to look up any information. If you're struggling with the case brief, please reach out to me and I can help you with that. So on that note, let's just pick up where we left off. The first part were the facts, procedure, history, and the issue. I'm also going to go through and talk about the case that you briefed and as far as where we're on this, but we're going to use the example of Boy Scouts of America. And so once we reviewed it, we determined that the facts were that the Boy Scouts had discovered that one of their longtime members was gay, so it revoked its membership. The Boy Scouts then had a mission that forbid membership to homosexuals, and so they asked him to leave. Dale sued, claiming that it violated New Jersey's public accommodation statute and common law because it was based solely on his sexual orientation. The procedural history, again, is the courts that it went through. And remember, it was the trial court found that the Boy Scouts could not be forced to accept Dale. But the New Jersey appellate court reversed, and the Supreme Court affirmed the appellate court. So basically, they said, hey, although the Boy Scouts said they could not be forced, the higher courts in New Jersey said, yes, we can. And so the United States Supreme Court took the petition. Now, the question is, does New York accommodations law violate the First Amendment if it requires an organization to accept homosexuals when the mission of the organization is contrary to the acceptance? So that's where we were left off on this one. So now we're going to brief the other components, and those involve the rule. First of all, there is a rule that's going to be applied to every case, and that's going to be the law, okay? So it's going to be what the law that the appellate court says, this is what we're going to use to apply to the facts in this case. Your holding is basically what the courts had decided to answer to your issue. So your issue is set up in a question as this is what they're trying to figure out, the court, and the holding is this is the answer. Yes, it does, or no, it doesn't. And then there's going to be reasoning, and 7 is going to be a disposition. Now, what is a disposition? A disposition is easy. It's the last line, usually, of your opinion. And the courts are either going to affirm, which means, hey, we're going to allow the decision of the court that we're reviewing, which is the court directly before it, to stand. We're going to modify it, perhaps, or we'll reverse and remand, saying, what the court before us did was wrong, and so we're going to remand this. Or harmless error, which a lot of times is mostly in criminal, and saying the trial judge did make an error, but you know what, it was so minor it didn't affect the outcome. The most common are going to be the affirm or the reverse. So let's continue on with this. So as we went through, we ended at the brief around this point. And the opinion. In Roberts v. United States Jaycees, we observed that implicit in the right to engage in activities protected by the First Amendment is a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. This right is crucial in preventing the majority from imposing its views on groups that would rather express others, perhaps unpopular ideas. Government actions that may unconstitutionally burden this freedom may take many forms, one of which is intrusion into the internal structure of affairs of an association, like a regulation that forces a group to accept members it does not desire. Forcing a group to accept certain members may impair the ability of the group to express those views, and only those views, that it intends to express. Thus, freedom of association plainly presupposes a freedom not to associate. The forced inclusion of an unwanted person in a group infringes the group's freedom of expressive association if the presence, I'm assuming, of that person affects in a significant way the group's ability to advocate public or private viewpoints. But the freedom of expressive association, like many freedoms, is not absolute. We have held that the freedom may be overridden, quote, by regulations adopted to serve compelling state interests unrelated to the suppression of ideas that cannot be accomplished by means significantly less restrictive of associational freedoms. We must then determine whether Dale's presence as an assistant scoutmaster would significantly burden the Boy Scouts' desire to not, quote, promote homosexual conduct as a legitimate form of behavior, unquote. As we give deference to an association's assertions regarding the nature of its expression, we must also give deference to an association's view of what would impair its expression. That is not to say that an expressive association can erect a shield against anti-discrimination laws by asserting that mere acceptance of a member from a particular group would impair its message. But here, Dale, by his own admission, is one of the group of gay scouts who have, quote, become leaders in their community and are open and honest about their sexual orientation, end quote. Dale was co-president of a gay and lesbian organization at college and remains a gay rights activist. Dale's presence in the Boy Scouts world, at the very least, forced the organization to send a message, both to the youth members and the world, that the Boy Scouts accepts homosexual conduct as a legitimate form of behavior. Hurley is illustrated on this point, and what they're doing here is they're referring to a court case. Hurley is the name of the court case. There we considered whether the application of Massachusetts public accommodation law to require the organizers of private St. Patrick's Day parade to include among the marchers an Irish American gay, lesbian, and bisexual group, GLIB, violated the parade organizers' First Amendment rights. We noted that the parade organizers did not wish to exclude the GLIB members because of their sexual orientation, but because they wanted to march behind a GLIB banner. We observed, whatever the reason, quote, whatever the reason, it boils down to choice of a speaker not to propound a particular point of view, and that choice is presumed to lie beyond the government's power. Here we have found that the Boy Scouts believes that homosexual conduct is inconsistent with the values it seeks to instill in its youth members. It will not, quote, promote homosexual conduct as a legitimate form of behavior, end quote. As the presence of GLIB in Boston's St. Patrick's Parade would have interfered with the parade organizers' choice not to propound a particular point of view, the presence of Dale as an assistant scoutmaster would just as surely interfere with the Boy Scouts' choice not to propound a point of view contrary to its beliefs. Having determined that the Boy Scouts is an expressive association that had the forced inclusion of Dale's would significantly affect its expression, we inquire whether the application of New Jersey's public accommodations law to require that the Boy Scouts accept Dale as an assistant scoutmaster runs afoul of the Scouts' freedom of expressive association. We conclude that it does. That is our holding right there. What they said is, this is what we've determined, and we have to inquire. So their inquiry, remember, was whether applying the public accommodations excuse me, ran afoul to freedom of expressive association. Their answer is, we conclude it does. So the holding in this case is right there. They go on to say, in Hurley, we applied traditional First Amendment analysis to hold the application of the Massachusetts public accommodation law to a parade violated the First Amendment rights of the parade organizers. We have already concluded that a state requirement that the Boy Scouts retain Dale as an assistant scoutmaster would significantly burden the organization's right to oppose or disfavor homosexual conduct. The state interest embodied in New Jersey's accommodation law do not justify a severe intrusion on the Boy Scouts' right to freedom of expressive association. That being said, we hold that the First Amendment prohibits the state from imposing such a requirement through the application of its public accommodations laws. We are not, as we must not be, guided by our views whether the Boy Scouts' teachings with respect to homosexual conduct are right or wrong. Public or judicial disapproval of a tenet of an organization's expression does not justify the state's effort to compel the organization to accept members where such acceptance would derogate from the organization's expressive message. Quote, while the law is free to something of conduct in place of harmful behavior, it is not free to interfere with the speech for no better reason than promoting an approval of something discouraging a disfavored one. I'm in the way. I can't read this here. But it's on the handout. Oh gosh, it's on the handout, and shoot, and it does not interfere with what we were saying. Okay, so I'm going to go through this right now. So what we have here is the first thing we have is the court is going to look to precedent for the rule of law. And what is the rule of law? In your own words, basically, if you were doing this one, is that forced inclusion of an unwanted person in a group infringes upon the group's freedom of expressive association if the presence of that person affects in a significant way the group's ability to advocate public or private viewpoints. But then it also goes on to say there's an exception to this rule, and that is that regulations, if they serve a compelling interest unrelated to the suppression of ideas, and they cannot be achieved through means significantly less restrictive of associational freedoms, may override that general rule. But the general rule is right there. And then the court applies the facts of the case to this rule. And the application of the facts of the case to the rule is the reasoning. So that's going to be your reasoning. And then the holding, basically having determined, that's what I said, is we conclude that it does. That's what we're talking about when we're talking about the holding. And then the disposition is at the bottom. And this is where I kind of got caught off on that slide. And it says, while the law is free to promote all sorts of conduct in place of harmful behavior, it is not free to interfere with speech for no better reason than promoting an approved message or discouraging a disfavored one. However enlightened either purpose may strike the government. And then it says the judgment of the New Jersey court is reversed and the case is remanded for further proceedings, not consistent with this opinion. That's your disposition, okay? So this is what the rest of your brief would look like. In your own words, just if I've done here. The holding is yes to my question when I have the issue. New York's accommodation law infringes on the Boy Scouts' First Amendment right by requiring them to include an individual who holds viewpoints contrary to its mission. The law, I kind of combine these two. The law really should be the first two paragraphs here. The United States Supreme Court has previously held the right to associate with others was implicit in the First Amendment of the Constitution. This right includes a right not to associate with others that do not share the same views. Forcing association with those whose values do not align with a group can restrict the ability of the group to freely express the views of the group. In looking to precedent, the court applied the rule of law, so here's my rule of law, that if a person's forced inclusion in a group significantly impacts the group's ability to advocate its view, it's a violation of the First Amendment. If the state has a compelling interest that does not involve suppression speech, that cannot be achieved through significantly less restrictive means than forced inclusion. This freedom of expression can be overridden. So that would be my rule of law. Reasoning. Your reasoning is applying the facts of this case to the law. That's how you start your sentence. Applying the facts of the case to the law. The court held that the forced inclusion of Dale would limit the Scouts' ability to express opposition to homosexuality. Further, the state's interest in its public accommodation law does not outweigh the burden. Therefore, requiring the Scouts to include Dale in its organization infringes on the group's right. And then the disposition is at very end. The U.S. Supreme Court reversed the decision of the New Jersey Supreme Court. So that's the second part of your brief. So we are going to take a look at what you briefed. And the issue was really right in that first paragraph, right? And it says the question we face is whether that course violates the free speech clause of the First Amendment. So we know part of the issue is we're challenging whether something violates the free speech clause of the First Amendment. But what? And what it is that there are laws that engage, or the laws that forbid businesses from engaging in discrimination when they sell goods and services to the public. If they force someone to engage in, or to require that they sell goods or services to someone who is going to make them espouse beliefs that aren't their own, does that violate the free speech clause? Okay, so your issue should be worded somehow along that line. Okay, what's the law we're talking about? We're talking about the free speech clause of the First Amendment. And what are we asking if it violates? What are we asking whether it violates or not? And that is these public laws that say we don't want you to discriminate when they force someone to produce or provide goods or services to something against their beliefs. And then you go through the facts, right? What's the important thing? She is going to offer websites for married people, and she is concerned that that law will make her offer services based on beliefs that she does not align with. And so what did she do? She went and filed an injunction, right? Because she was concerned. And that's all through here. Now, you don't need all these facts in there. You want to keep it brief, but you want to put the necessary facts in there. So, what was your procedural history? Well, first of all, she filed a lawsuit in district court, right? And what'd she do? She sought an injunction, and to prevent the state from forcing her to create the wedding websites or fining her or whatever. And what happened then? Well, the district court ruled against her, and so did the 10th Circuit, right? She appealed in the 10th Circuit. So this should really say the U.S. Supreme granted cert to review the 10th Circuit disposition. Because this is all going to be in your own words, right? So instead of copying and pasting this, you need to say, wait a second, she filed a lawsuit in federal district court for an injunction. District court and the 10th Circuit ruled against her, and the U.S. Supreme Court granted petition for review. So this is what your first part should look like. So now you need to take the second part of the assignment and say, okay, well, what did they decide on our issue of whether or not it violated the First Amendment, right? What was the law they used to determine that, and what was their reasoning, meaning how did they apply the facts of the case to the law in this case? And then finally, what was the disposition? What was the final thing that happened with the case? So again, this needs to be in all your own words and all your own work. If you have any questions, please feel free to contact me.